Welcome to Work This Way, a labor and employment podcast. I'm Tina Emerson, joined today with Maynard Nexsen attorney Jennie Cluverius. Good to see you again, Jennie.
Good to see you, Tina.
Today, we're welcoming back Maynard Nexsen attorney David Garrett, who heads up the firm's immigration and global mobility practice. Good to see you, David.
Good to see you too, Tina.
You too. Well, so much has been changing regarding immigration this year, for sure, and many employers have questions about hiring and retaining foreign nationals. And since January, it's been a really challenging year with the new administration's positions on ending a lot of parole programs and temporary protected status programs. And the talking points we hear on the news are changing significantly in the past several weeks.
Yeah, Tina, you're right. You know, the change of administration has been extraordinary these past 7 months with the changes that we've been seeing, particularly in this area of law. You know, there's been an awful lot of news media coverage about this, and it seems to be what every person is talking about, you know, even just like casual conversations on the street. So, you know, we've been having, I think, an amazing year so far. A lot of the issues that we're seeing coming from our clients, you know, have been these issues that we're hearing about on the news. For example, the termination recently of many of the TPS, that's a temporary protected status programs, and parole status, such as CHNV parole, has impacted, you know, many employers across the United States and some of our clients, you know, quite significantly. There's also, in the past several weeks, been a new implementation of E-Verify, where E-Verify is actually, you know, through their own system, issuing work authorization revocation notices as being like a new feature of E-Verify. So employers are having to navigate that along with the termination of the legal status of many of their employees. Something else too is that we're seeing the talking points change over the past several weeks. You know, we've been seeing a lot more talk in the news media by government officials about worksite enforcement actions. So we've been preparing our clients, I think, pretty well for what may be coming ahead in the upcoming months. Many of our clients have been well prepared for this, but this is a good time for everybody to be kind of very thoughtful about that. And lastly, you know, a lot of our clients are asking us questions about, well, you know, we have workers that that have been working for us, and we're trying to figure out ways to like legally keep those workers in the United States. You know, whether that they have already been here legally, if they've been, you know, on a parole status that had been terminated, or in some cases, we're getting questions from clients and from others that I have some questionable, you know, real questions about the legal status of their employees. You know, and one of the most frequent questions that we get is like, you know, how do we keep our employees?
Well, David, let's just go straight to the question that everyone wants to know the answer to, and that is, if an employer has been employing a worker illegally, is there a way for the employer to get them documented?
Yeah, this is a very common question, and you know, it's kind of a technical answer, and I'll try to like address this, you know, from a non-technical point of view. It may actually be possible to get approval for a non-immigrant visa, such as an H-1B if they're qualified for it, or maybe an H-2B visa for if they would qualify as being a temporary labor type worker, and it might also be possible for the company to get an employment-based immigrant visa, a petition approved for that particular worker. But there's a catch, and that particular catch is that if the worker has been in the United States for more than 180 days without status, that is, if they've accrued something called unlawful status in the United States, then in almost every case, there's either a 3-year or a 10-year bar to their legal ability to be admissible to the United States on either an immigrant or non-immigrant visa. So it can be possible to actually get visa approval. And in some of these cases, you know, it could take a while, but, you know, at the end of the day, hey, you get this visa approval and everybody would feel fantastic about it. But when it comes to the very moment that they're trying to seek admission to the United States, precisely when they're going to an overseas embassy to get that visa and their passport, that's when they're going to get their denial. So in many cases, if there is a worker that has been working for a company that has been that's undocumented, there's no real practical way to bring them back to the United States legally without having to deal with that 3 or 10-year bar.
Well, what if the employee left using that new CBP Home app? Doesn't the government say that using the app can get them cost-free travel home, $1,000 exit bonus, and the ability to lawfully return to the U.S. in the future?
Yeah, that's what the government's saying, and they're putting this out on a lot of different, news media. It's on the government's websites. It's even contained within the CBP Home app itself, and the government is advertising that leaving voluntarily, using the CBP Home app may, quotes, may improve future immigration options. But none of the public statements about using the CBP Home app discloses anything about the 3 or 10-year bar. The 3 or 10-year bar that's a statutory bar to being admissible to the United States. That's something that Congress would have to take care of. That's the only way to deal with that, is to have Congress go and make changes to the statutes regarding admissibility to the United States. So the 3 and 10-year bar, just kind of focus in on this for just a moment. That actually, we call that the accrual of unlawful presence. And unlawful presence is a concept that we have in immigration law, where if somebody has accrued more than 180 days or 365 days after the expiration of their visa or their authorized stay in the United States, or if they're present in the United States without either being admitted or paroled into the United States, then they are genuinely accruing something called unlawful presence. Now, there are some very important exceptions to the accrual of unlawful presence, but the unlawful presence, that can be, the bar to reentering the United States lawfully, even if somebody has left the United States using the CBP Home app. So even though the government is saying this and they're saying, hey, it may improve future immigration options, there's really no way to get around that 3 and 10-year bar other than seeking a waiver of that bar, which could happen, but that would be quite extraordinary for those waivers to be granted. Another way that is probably not one of the most advisable ways to try to get over the 3 or 10-year bar if there's been a technical status violation, is that the 3 or 10-year bar does not apply if somebody has been granted something called voluntary departure after they've appeared in an immigration court. In the past, in some particularly terrible case where something has happened, and we have to sometimes we want to affirmatively put somebody into removal proceedings so that we can go to the court, concede removability, and then seek voluntary departure. The issue with the I guess the good part about voluntary departure is that it would not have the 3 or 10-year bar attached to that. But the downside of it right now is that after July 8th, the administration has determined that they're going to be placing everybody who is in removal proceedings into mandatory detention. Now, whether or not that's lawful or not, I think that's something that the courts will have to address moving forward. But right now, trying to get around a 3 or 10-year bar by going to immigration court in removal proceedings and seeking voluntary departure is really not a viable option anymore.
Wow, David. Well, there's a ton of fluctuation and change in the immigration and global mobility space right now. Tell us what the most frequent question is that your clients are asking today.
Yeah, the most frequent question is, I have all these employees that we employ. Most of them are on visa, have currently valid visas. How can I change their visas into something more permanent? How can I get them a green card, is what the question is. And that particular process is kind of a long and drawn out one. And it's one that I think many companies are looking a lot to these days, because they're looking for two things. First of all, the company itself, they need to have employees working for them. A company is based off their employees, and if their employees are not able to be there and work for them, the company is not going to be able to do the work that's necessary. So having employees, man, that's really, really high up on our priority list. And the second reason is they know that the employees that have been working for them, even though that they might be working on a valid H-1B or L-1A or H-2B or whatever visa classification that they're in, these employees are seeking permanence in their lives, and they're just like you and me. They want to have a family, they want to be able to buy a house, and know that they're going to be able to remain lawfully in the United States for the long haul. So most of our clients have been saying, hey, we were considering the green card process maybe several years from now, but we want to start that a lot earlier. and we want to start this. And it's really kind of the best way to look at it is that it's a process. It's not something that anybody can just like snap their fingers and get a green card. For most visa cases, employment-based visa cases, there are two different employment-based preferences for green cards. And here we talk about those that are in the employment-based second preference and employment-based third preference. And those are, we call them EB2 and EB3 green card cases. And in almost all of those cases, there needs to be it's a lot of strategy that's involved. The first stage is that we have to go to get a prevailing wage determination for that particular occupation in the geographic area where the work is being performed. That prevailing wage determination is a very, very key step in the process, because there you're having to figure out what are the actual minimum requirements for the job. What type of education does somebody need? How many years of experience? Do they need to have any special skills? We take all that, we put it together, then we send it off to a government agency that's called the National Prevailing Wage Determination Center. The NPWC, then they're taking about, sometimes 6 to 8 months to respond back with just a number. That's the prevailing wage determination. After that, the next step is that we have to be able to be in a position so we can prove that the hiring of this foreign worker is not taking the job away from a ready, willing, and able U.S. worker. So that means that we have to prove a negative, that we have to go out and put out advertisements in a very, very structured way. This recruitment period in many states, because there might be like a veterans look at upcoming job periods. In many states, it amounts to being about 63 days in practice. And in reality, because we need to get all bunch of sorts of affidavits from like radio stations and newspapers and every place else that we've placed the ads, it typically takes about 70 days to 80 days in order to have the to go through the recruitment process to prove that negative, that there isn't a ready, willing, and able U.S. worker for that position. After that point, then we're able to go to the U.S. Department of Labor and seek something called labor certification. Labor certification goes by a lot of different names. On the internet, most people call it PERM. So we make a PERM filing, and there we're actually seeking a document that's called an ETA 9089, which is a labor certification from the Department of Labor, where this is proof positive from the U.S. Department of Labor that there are no ready, willing, and able U.S. workers for that position. Once we get that part is taking about, after filing, it's taking about 14 months in order to receive on a non-audited PERM application. So you can already add up here like 8 months plus 70, 80 days plus another 14 months. This is going to be a multi-year process, isn't it? Just to get what will eventually turn out to be Exhibit A to the company's green card application. Once we finally get the labor certification approved, that is, the PERM is approved, that then becomes Exhibit A to the company's green card application. And at that point, I have to prove two other things. I have to prove that the worker is qualified and able to perform the job. So they meet those minimum skills, they have the minimum educational qualifications, and they have the minimum number of years of experience. So, at that point, we've got that, right? So we've been working on this case for years at this point. So we are able to prove that the worker meets the minimum qualifications. And then finally, we have to be able to show that the company has a financial ability to pay that wage, that prevailing wage that we got how many months ago? That's when we're able to file and seek approval of the immigrant visa petition. And the very last stage of that process is where we're having to wait for the person's priority date to become current. The priority date, that is their place in line to get a green card, is established on the date that we file the PERM. That is the date that we file the labor certification with the Department of Labor. And it really kind of, at this point, depends on what country the individual's from. So on the farthest reaches, if somebody's from India, as of this month in August of 2025, priority dates for India in both the EB2 and the EB3 visa classifications, they're working on cases with a priority date of 2013. So, if you can imagine that, if you were from India, you're having to wait, between 2013, it's the last time that they have been working on those cases. But people from Mexico, Philippines, and from the rest of the world, and the visa bulletin for August of 2025, they're working on cases with priority dates in EB2 and EB3 classifications in 2023. So if it's taking us, 14 months or so in order to get the PERM to be approved, then the priority date is actually going to be coming up fairly current after we get an immigrant visa approval. But you can see that for most people that this is going to be a multi-year process.
Well, with all the time that it takes and all the hoops to jump through to get these things approved, being successful really is the bottom line, right? So with employers wanting to successfully navigate this process, what are some of the most important strategies and considerations that they have to think about to make sure they're doing this whole thing right?
Yeah, yeah. So, patience and a really good technical strategy is actually the key to success here, right? So every case is different. Every case has to be planned out. It's very common that we hear people say, "Hey, I know a friend who got their green card in 2 years. Why is it taking me 5?" Every single case is different, and every person who gets a real legitimate green card in the United States, they each have their own fantastic story to tell. The green card process is run in parallel to their workers' non-immigrant visa processes. So they're separate, but in some cases, there's actually has to be like a lot of strategy in between the two. So depending on the type of non-immigrant visa, that's the visa that the worker is working for a company on today, like say the H-1B visa or the TN visa or the L, or whatever visa that they're on. There can be sometimes a lot of strategy and interplay between the timing and the way that the green card process is drawn out. The TN visa and the H-1B visa can be some great examples of that. For in the H-1B visa process, if the green card timing is just right, so if the maximum time period for somebody on H-1B visa is a maximum of 6 years. But if the green card process has been started in the right time before the expiration of the 6 years, then the H-1B visa can be extended indefinitely until the green card is finally available to them. And that's exactly how, the vast majority of people from India with priority dates of 2013, that's how they've been here. They've been working on an H-1B visa, for that many years and even longer. So there can be a lot of interplay and a lot of strategy that's being put into these cases. A lot of thought is involved.
David, recently there have been a lot of news stories and reporting regarding individuals being detained at airports and then deported. Can you explain to us what's really going on there? What's happening here?
Yeah, yeah. From my perspective, we've been seeing this. I've been in this practice for going on 24 years now, and Mike actually kind of see this as being somewhat of a pendulum that swings back and forth between a lot of heavy enforcement and lax enforcement and heavy enforcement. So it's a pendulum that swifts over years. The pendulum has shifted toward heavy enforcement during both of types of presidential administrations, both Republican and Democrat. For example, during the Obama administration, most immigration attorneys were actually calling President Obama the deporter in chief. And President Obama, it was much more quiet about the way his administration was going about doing it. But there are documented more than 3.2 million people that were deported during his presidential administration. And over that period of time, it's believed that an additional 2 to 6 million people self-deported because of the difficulties that the Obama administration had been placed onto the immigrant community. It's true to be said, I think President Trump has a ways to go in order to beat President Obama's numbers in that. But the vast majority of travelers into the United States are not actually having any difficulties, particularly if they have legitimate reasons for traveling to the United States and have well-prepared visa cases if they're into the United States on a visa. So it's here in the news. I think it's really easy to assume that like nobody's being allowed into the United States and people are getting picked up and placed into deportation left and right. But in reality, almost 200,000 international travelers enter the United States successfully every single day. And over the past year, that's been about 72.4 million international travelers coming into the United States. And kind of like zooming out just a little bit more, I was looking at the numbers just last night and saw that Customs and Border Protection reported 31.8 million passenger arrivals in June of 2025. That's over 1 million people a day, both U.S. citizens and foreign travelers coming into the United States that are entering the United States lawfully and not having any problems at all in being welcomed into the United States. So, those people that have I think the good fortune of having a well-prepared employment-based visa, they are having no problems at all coming into the United States.
Well, David, thank you for this information. I would just like to remind our listeners that Maynard Nexsen's Immigration and Global Mobility Team is here to help, including as the pendulum swings back and forth. David, we have a team of experienced attorneys and paralegals who help our clients stay compliant with U.S. immigration laws and help their businesses bring their most valuable workers into the United States. And when they need to move their workers to a different country, we can also assist with that.
Absolutely. Well, thank you so much for joining us, David. Thank you, Jennie, for being here. And as these immigration issues move back and forth with our administration, we will keep you posted. And we'll see you next time on Work This Way.